Good morning, Mr. Glexler.
Morning, Your Honor, members of the court. May it please the court, thank you for hearing us on this matter today. Back in 1990, Justice Greenberg of the Superior Court wrote findings with regard to a preliminary injunction regarding overcrowding at the Middlesex County House of Corrections. And he commented, and it's on page 16 of my brief, although crowding continues, current conditions would be far worse were it not for the initiatives undertaken by the Sheriff's Administration over the years.
Does the record, by the way, show that overcrowding would prevent a separation of work release participants from the general population?
We've made, the sheriff has made every effort to conform with the statute to keep those people separate, because that's what the statute, the work release statute, requires. And under 86F, it says they have to be kept in a separate place. It does not specify where that place has to be, and it doesn't describe the place. I believe that that's left up to the discretion of the sheriff or the keeper of the particular correctional facility.
Mr. Draxler,
Yes, sir.
is it your position that the sheriff could decide to release an inmate within a week or two of their being committed to the sheriff's custody?
Absolutely not. Absolutely not.
Well, why does he draw the line at mandatory minimums? How are mandatory minimums different from an order of the court?
Well, there are two factors, I think, that restrain his discretion. One is statutorily. One is that the mandatory minimum language, he has adhered to that. We aren't testing that today. My client has scrupulously...
Well, why does he decide that he has to adhere to the mandatory minimum but not to an order of the Superior Court?
Well, because the statute, I would suggest to the court that the inclusion in the various mandatory minimum statutes of that strict language that we're all used to reading under the drug mandatories, under the gun mandatory, under the OUI mandatory, has to mean something. And the reason the legislature did that, and Cowan, the case that this court decided, relies on that language, that mandatory minimum language, to say that you can't put somebody on home confinement. If the court meant to say that you could never do it, then I believe this court would have said that in Cowan.
No, you can do it when the court so orders.
But let me ask you this: are you saying that when the minimus says in the custody of the sheriff gets to define where custody is? So in this instance, would you say that the home of Mr. Donohue is a correctional facility and the as defined in the statute?
Well, there are a number of yes and no. There are a number of restrictions on his discretion statutorily. Number one, the mandatory minimum language. We're not disputing that. And Mr. Donohue did 195 days, which is well over the minimum 150 or 180, depending on how you read the statute that's required. But, Justice Botsford, I'd like to point out to you the language in 127, Section 49, which is one of the statutes we rely on. And that says that you can only put someone on a program outside of the facility if he is within 18 months of his parole date. Mr. Donohue was within 3 months, less than 3 months.
Let me ask you this: when you say outside of the facility, because maybe I'm just trying to understand where you're coming from. And you could be saying the sheriff can classify and can deem, because the definition of correctional facility is pretty broad, can deem somebody's home as sort of a facility where he can send somebody, and could do it really at any time absent some specific language about you've got to be in the House of Correction. Or you could be saying we can do this, the sheriff can do this as part of, in connection with a work release under Section 49 or 86F, and it's the space question. Is that your argument?
I'm saying that he can do it under 86F and 49 and 48 and 49A read together. I believe these statutes within, as long as the prisoner is within 18 months.
All right.
Okay, and if the person leaves his home and goes to New York, is he subject to prosecution under an escape from an institution?
Yes, as a matter of fact, 127.
So you would say the house is an institution. His home is an institution.
Well, because under 127.49 there are specifically criminal penalties that are proscribed for an inmate who, having been ordered by the commissioner or such administrator, who would be the sheriff, to return to the correctional facility neglects or refuses to do so, he'll be held to have escaped. Under 86F, there is also a specific provision for escape if a prisoner doesn't return. If you look at the record appendix of the program and the outlines of it, there's pretty strict criteria: urine test, daily calling, GPS monitoring. And I have to say that the program as it existed at the time of Judge Kottmeyer's order is a far cry in terms of the level of security and public safety from the program as it existed back at the time of Justice Greenberg's order in 1990. The trial court makes an argument that somehow or other it's not the same, or that the program back then was even more restrictive. I don't know how that can possibly be. If you look at the materials that I provided, GPS monitoring is the most technologically advanced method of ensuring public safety, but at the same time allowing someone to reintegrate.
If we accept your argument, then what do Superior Court judges do, or District Court judges for that matter, when they're sentencing someone? They won't really have any idea how long the person is going to serve in what we call custody, other than if there happens to be a mandatory minimum. If there's not a mandatory minimum, or beyond the mandatory minimum, they have no idea. And how would they adjust if they want a person to stay in what we consider a facility, how do they do that?
Well, first of all, there's the other restriction under Section 49, which you can't do it until there's 18 months left in your sentence.
I understand that. But
There's
most
also a provision.
sentences to the House of Correction, I mean, great many sentences aren't that much more than 18 months long.
Well, it also requires that you can permit an inmate who has served such a portion of his sentence or sentences. It requires that you serve a certain portion of the sentence as well.
So
I
in
think
other
you
words,
need to.
there's like a mandatory minimum that the judge knows. Got to learn, but it knows that the person is going to serve. But other than that, they could be released to their home, to the bracelet, at any time.
That's not what was happening, but yes, that if
Well, that's
you
how the judge
comply
has
with the
to think.
statutory strictures.
But that's how the judge has to think.
But it's not just a bracelet. He has to be employed. He has to be engaged in an educational program. He has to be engaged in a training program. You can't just let him go on home confinement. And that's how this case, I think, differs from pretrial home confinement.
So if you prevail, the judge could not even explicitly in the sentence say that you can't do what he, in this case it's a he, wanted to do. In other words, if this judge at the original sentencing had said there'll be no work release, this is to be served, no work release, no GPS, blah, blah, blah. They couldn't do that, right? That would encroach on an executive power.
I'm certainly, on the face of it, we're taking the position it would encroach on the executive power of the elected official who's answerable to the electorate.
But if you do what I'm talking about, make it explicit, which it wasn't here because the judge didn't think it was going to happen, you couldn't do that either.
I'm not so sure about that, and I'm not going to, in other words, that's a different issue from what I researched and wrote before the court.
Because we used to say, with some defendants, I don't know if they do anymore, that you wanted, in part of your sentence, we used to say to serve all of this sentence, or to serve, and go beyond, actually. We'd actually say it had to go beyond what the parole parameters were.
I think that would present a different question, because if the court...
Mr. Drexler,
Yes,
I'm looking, I've got Judge Kottmeyer's order of September the 21st, and as I understand it, the minimus said, and to imprison and employ him, the defendant, in and within the precincts of the House of Correction, Billerica, for and during the time of 2.5 years, 18 months to be served. I mean, that's pretty explicit.
Yeah, but
Well, but every minimus says that.
No, I understand,
and-
but it's pretty explicit. So, I mean, I don't know how much more explicit you're going to say. Well, notwithstanding the fact that everyone says in and within the precincts, I really mean in and within. I mean, how are you going to say it?
But I don't think there's any question but that we wouldn't be here if the issue was had the sheriff moved Mr. Donohue from Billerica to Charles Street or
No, I
South
understand
Bay.
that. I understand that.
Well, but the statute which governs the sheriff's conduct,
Yeah.
and there is a separation of power, and he's bound, the sheriff is bound by what the legislature allows him to do.
And you're saying that the legislature, at least given the fact that this has been going on for 20 years, not necessarily with the GPS, but the interpretation that the sheriff has given the statute is something that has received the blessing of the legislature.
It's specifically allowed in the statutes that I've cited, 127, 49, the way I read them together, and I've made the argument in my brief, 48, 49, 49A, and 86F. It's also, just to bolster the sheriff's position, this isn't only Sheriff DePaula. He was using this program to the probably the most minimal extent of any sheriff in the Commonwealth. He only had never more than 10 or 15. The same number has existed at the time of Judge Greenberg's order out there. Other counties have 100, 50, 60, 70, or 80. He's been very, very conservative. And since this order came down, right now he doesn't have anybody.
How do
Let
we,
me ask you this. Then, if a judge wanted a person to be held securely in a facility, what they'd have to do is give a longer sentence, understanding that that the sheriff could release the inmate once they were within 18 months of the end of their sentence. So, give them a longer sentence. That means that the sheriff has to hold them longer. Is that what you're saying?
I'd prefer to look at it that if a judge of the sentencing court made an explicit order that someone not be given the advantage of one of these programs, the sheriff would certainly have to take a long, hard look at that. And I can speak for Sheriff DePaula in saying that if that type of specific order was entered, he and the members of his staff who do the classification process have never and would never ignore the court's thoughts, feelings, and orders in that regard. But if the statute allows you to do it, not only is the statute allowed it, but the Executive Office of Public Safety and the Department of Corrections have issued regulations, which I've cited in the brief, and I should acknowledge the brief of the amicus brief of CPCS comes up with another one, which is 103 CMR 95201. They explicitly provide for community release programs, for bracelet programs and home confinement. They allow for this, and a judge of the Superior Court approved an order, two judges actually, Justice Greenberg, Judge Brady in 1993 when it became an agreement for judgment. For 20 years, the sheriff has operated under an order which says that he has to not only use the bracelet program, the home confinement day reporting, as it was referred to then, and as it was referred to by Justice Kottmeyer in her remarks, it's on the transcript, she refers to it as day reporting. A much more secure form of day reporting, I might add, today. And for 20 years, the sheriff, or 18 years, this sheriff, who's bound by that agreement for judgment, has attempted to comply. Now, I view Judge Kottmeyer's order as ordering him to do something that legally another judge told him he better do.
but I
Mr.
have a
Drexler,
question
can
for
I-
what you said before. You said that we can assume that the legislature knows that all these people are on these work release programs or, the bracelet programs. How can we assume that? It's one thing we say we assume that the legislature is aware of our cases, but Judge Kottmeyer obviously wasn't aware that this was going on. I never knew this was going on. I sat in the Superior Court for years. I would dare say that before this case was decided, there were many judges on the Superior Court who didn't know this was going on. So what makes us assume that the legislature knew this was going on?
Well, the legislature has never prohibited this practice. In fact,
No, but what I'm saying, what gives you how can you say we assume that the legislature knew that these sheriffs in the different counties are letting these hundreds of people go out every year on this program for 20 years or whatever, when most people, or some people at least in the Superior Court, thought that this was not happening while a person was sentenced to an institution, while the order that the Chief Justice read was in effect.
if I said I thought the legislature knew, I think I misspoke. I meant the
I
members
might
of
have
the court.
misunderstood you.
No, wait a minute. Doesn't the legislature fund the GPS program?
Well, the legislature funds the sheriff's department.
Yes, but
and
the GPS program is
Yes.
used for probation all the time.
this is different.
I know that, but when you're saying that they fund it and people know and the legislature knows it's funding it, how do we know that they're funding it for people who are going out prior to the expiration of a sentence and not on probation?
The Secretary of Public Safety, in the letter which is attached at the end of the last portion of my record appendix, not only acknowledges that, they fund it, and they praise the program and say it's a necessary adjunct to reintegration into society. It's only used for prisoners who are within, as a practical matter, within the last couple of months of their sentence. How does the court know? That Justice Greenberg and Justice Brady approved an agreement for judgment which ordered my client to use his best efforts to not only use the program but expand it.
Can I ask you this question?
Yes, Your Honor.
It was not clear to me, maybe I should have read between the lines. Does the Department of Correction have a similar home confinement program?
Yes, and in fact, it is, again, in two places in the CMRs that are promulgated by the Department of Correction, which are binding, which are applicable under the beginning, the other sites to the sheriffs, 103 CMR 95201, and I believe it's 420.08. And in the beginning of 103, there is in the beginning of 103.420, it indicates that these regulations are applicable to the county administrators.
So there are such programs, and presumably they would be authorized by the same statutory provisions that you were indicating the sheriff's office.
Yes, and I think there's a good description of them in Secretary Burke's letter, which the trial court allowed us to add to the record appendix in this particular
Wexler, could
case.
I ask you a slightly different question?
Yes, Your
as you know, in the CPCS brief, they challenged the procedure that was followed here. In
Yes.
other words, essentially saying, I realize the judge issued an order to show cause because somehow the information had come to her. It's not clear to me how it came to her. Did you challenge the procedure?
I did. If you look at the transcript, I said there's no case or controversy before the court. No case or controversy. I said it several times at the second hearing when I was present. I should also add that one of the reasons that we brought Justice Greenberg's opinion in that litigation to the attention of the court in maybe I should have called it a motion to vacate or motion to reconsider, however you want to characterize it, is we were in front of the court, I felt, on the Donohue matter. What ended up happening was a general injunction against the sheriff from ever doing this. And at that point, we had no choice, I felt, and the sheriff had no choice but to come before the court and attempt to seek a clarification of his situation. I want to just, if I can have one more.
Let me just ask you one question. Let me explore the flip side of this. If a judge were to order, and the minimus reflected this kind of home confinement, would the sheriff feel obligated to honor that order?
Well, again, a different issue that I would have to take a long look at, but I certainly think that isn't what happened here, and were we to research that, do I think he'd have to? I'm not sure that I would agree with that. Do I think that he may have to? That's a different issue if it was explicitly stated in the order, and it wasn't. I want to point out, if I can.
Mr. Drexler, I hate to interrupt you, but your time is up, and we have a very long list today.
I understand.
Thank you, Mr.
Thank you very much
Drexler.
for hearing us.
Mr. Ravitz?
May it please the Court, Randall Ravitz on behalf of the Superior Court.
Mr. Ravitz, I hate to interrupt you right at the beginning, but it would be very helpful to me if you would just discuss briefly the Attorney General's position on the procedure that was followed in this case.
Well, the procedure was proper because this represented an exercise of the court's inherent authority. And so it was something different than the way it's been described in, for example, one of the briefs by the amici. The sheriff here did not, the court here did not resentence offenders, did not open up their cases. The sheriff, the court only issued an order pursuant to its authority to ensure that the sheriff was complying with his duties to execute sentences and not to invade the authority of the court.
It was essentially, I take it, a polite contempt proceeding.
Well, contempt is a power that also is derived from inherent authority. And while this isn't a contempt, technically, certainly the sheriff does not have a criminal judgment against him, and it wasn't a civil contempt because it's not, there wasn't.
But the sheriff is under a court order.
That's right.
And the judge sensed that this court order was not being honored. And isn't contempt the traditional method for enforcing court orders?
Contempt is one form of an exercise of inherent authority. And it's different. Presumably that the sheriff here would not want to have a contempt judgment against him rather than simply an order directing him to comply with the court's directives. But there are prior cases where this court has recognized the exercise of inherent authority in analogous situations. It has stated, and we didn't necessarily cite all of these cases in our brief because a lot of these propositions are in response to the CPCS amici's argument, but this court has stated that in Bate versus Probate and Family Court that inherent authority includes the power to make the court's lawful orders effective. In Aucoins, which we did cite, this court stated that that the authority can be exercised ex parte, and that it could be used to direct a government agency to make payments that the court has contracted for because those payments are necessary for the court to function.
Mr. Levitz,
Yes.
do we know what the circumstances were? And I mean, it's stated in the subjunctive that, I mean, in the passive voice, that it was reported to the court, this is in her September 21st order, that the defendant had been released from the House of Corrections.
What's in the record is that the defendant had moved for the appointment of counsel on the basis of indigency, and the court ordered him haved in for a hearing on that, and he came in accompanied by a deputy sheriff, and it then became known to the court that, in fact, he had been released to his home as part of this program.
Counsel, it strikes me that, and I may be very wrong about this, I'm trying to piece some of these things together, that both the Department of Correction and the Sheriff's Department have been running these programs for at least 20 years under the authority of Section 48 and 49 in any event. Is that wrong?
Well, certainly we say it's wrong that the way that it's being done, that's at issue in this case, is consistent with 48, 49, and 86F. But as far as the programs existing, we don't dispute that, and we don't dispute the fact that they can continue to exist. In fact, the judge here stated in the hearing, the court finds these to be valuable programs and uses them all the time. But what she also stated in her decision of October 1st is that where the court has decided not to put someone into this program, it means that it was based on a reasoned decision by the court that it's not appropriate.
But it's not the court's decision. 48 and 49 really aren't dependent on the courts doing anything. That's what correction officer, what sheriffs and commissioners can do within their institutions and with their prisoners while they're in custody.
And if this were covered by those statutes, I would have a much harder argument.
The sheriffs make an argument that they are, and it strikes me that not only that, but if you look at this 1988 letter written by the General Counsel of the Executive Office, I guess, of Human Services, which is where the Department of Correction was back then, basically says, sure, the department has the authority to run these kinds of programs under 48 and 49, and so do the sheriffs.
Actually, what the letter says, Your Honor, I'm sorry, is to the extent that the department has the authority to do it, then the sheriff does also.
Well, that's very interesting, but and the answer is, does the department have authority?
No, not in the
And
way.
it doesn't run these programs?
Let me be clear. Not in the way that we're talking about here, which is the sheriff or the correctional official releasing someone to this program before the end of the period of confinement that they were directed to serve in their sentence. And I can explain why 48, 49, and 86F are distinguishable.
I've read your brief, and I see how you lay that out, but I'm reading this letter. It says, to the extent that DOC has authority to establish home confinement programs under these sections, the counties also possess such authority. Don't you think that the letter would have said that DOC doesn't have the authority and therefore the sheriffs don't?
No, it struck me that the author of the letter was careful not to take a position on that issue explicitly. I look at it the other way, that the author, if the author was saying, yes, there's authority, the author would have said that. That would have been a much clearer legal opinion if that's what the author intended. But in any event, that letter from the DOC commissioner is not sufficient to trump these statutes and the limitations placed by the legislature.
I understand that, but this all has to do, I don't think the statutes are so crystal clear, frankly, as you suggest they are. I think that it does provide an interpretive issue and question. And this letter, written early on, what by the way, is the supple program, which is what the Department of Corrections was running at the time under Sections 48 and 49. Was that a home confinement program?
Your Honor, I don't know. I'm sorry.
Because that's what this is all about, whether sheriffs can set up similar home confinement programs. So I'm just assuming it was a home confinement program.
Your Honor, if I could try and persuade you as with respect to 48, 49, and 86F, I'll just focus on one point that we think is probably the most critical point in those statutes, is that it talks about, it authorizes
Which statute are you talking about?
I'm sorry. Well, that's part of it, Your Honor, is that...
No, I've got 48.
The
49
statutes have to be read in tandem.
Okay.
So if you forgive me, please, the language that I'm about to cite is 86F, but
Okay.
it's incorporated into 48, and 48 is incorporated into 49. But it authorizes it to the extent necessary and reasonable for working at gainful employment or geared to seeking such employment and obtaining educational training in connection therewith. What the sheriff does is to take the words necessary and reasonable and take them out of context and just look at them in isolation and say, aha, we can release someone to the extent that it's necessary and reasonable. Well, that begs the question, necessary for what? Reasonable for what? I mean, surely the legislature wasn't saying you could release them whenever you think it's necessary or reasonable. The context indicates that it's necessary and reasonable for working at gainful employment or seeking it or educational training in connection therewith. It also sets forth, in addition to what's in 48 and 49, there's also 49A, and all of them together set forth a series of procedures. And if you read the sheriff's policy, while he described it to the lower court as a work release program, it doesn't seem to perfectly track the language of the statutes. And at the beginning it cites certain authority that it's issued pursuant to, and it doesn't mention 48, 49, and 86F. So in reality, it would appear that these statutes were not even really what the sheriff had in mind. Not that's dispositive, but...
Go ahead. What's at issue in this case? Is the question before us whether or not the sheriff violated a court order, or is the question before us whether or not the sheriff has authority under the statutory sentencing scheme to order or to allow this person to live at home under a GPS confinement system?
Well, the two work together, because if the sheriff had statutory authority to do this program the way he's doing it and the way that it's at issue, it would be deemed incorporated into the sentence. So then there would be no violation of de minimis or the sentence for the sheriff to do it. But here, because there is no statutory authority, then what we have is essentially the sheriff resentencing the offender.
So if the sheriff does have authority to do what he did, then that answers that's dispositive of the entire case.
Yes.
Yeah, and that's, in fact, that will be consistent with Justice Kottmeyer's
That's
ruling.
absolutely.
She's saying he does not have the authority, and I assume she means statutory authority or,
Yes.
or appropriate regulations.
And I take it the same statutory, if the Department of Corrections, under these same statutes, was permitted to run a home confinement program with a work or educational component, as this program is being run, then the sheriffs would be able to do the same.
Yes.
Well, how do you describe Judge Greenberg's involvement years before? What was he doing?
Well, Judge Green...
What did he approve
what
and
Judge...
encourage?
Right. What Judge Greenberg approved was the sheriff's use of his best efforts to expand the use of this program. Again, we're not saying the program needs to be dismantled, and we're not saying that he can't continue to use his best efforts. We're just saying that it must be circumscribed by what is lawful. And in fact, the judge said that there, said this order is not intended to restrict or change any constitutional or legal responsibilities. But what the sheriff's argument leads to the conclusion, and the amici's argument leads to the conclusion, that because of this one superior court order with circumstances that may or may not have been the same, where the court didn't even take up the constitutional issue, that now everyone's hands are tied. Not only the
The
superior
underlying
court...
problem was overcrowding, wasn't it?
Yes, and so that's another way in which it's distinguishable.
And that's what you have now, isn't it?
Well, but it arose out of a case where there was at least some finding about that. There was an action, class action, based on overcrowding, and there were findings that the
Well, is
plaintiffs
that
were
order
likely
still,
to
that order is
succeed.
still in effect, is it not?
Technically, yes.
Judge Brady's is. I mean, sort of.
Do we
Take a
really
look,
need
Mr.
to even
Evans?
consider that order in this case, to reach a decision in this case?
No, it couldn't be the case that if the sheriff's program were unlawful, that somehow that order would excuse that.
Except
The order also directs a whole different set of credits against sentences,
Which
which
are
clearly
specific.
violates the
Right.
law.
That's right. We don't dispute that. And I think even the
I think
sheriff
the
has
Commonwealth
acknowledged that.
well, never mind. Okay.
Mr. Ravitz, let me just... maybe I'm missing something because I obviously have a head cold and my brain is not functioning very well. Section 86F establishes a work release program. And assuming that what was happening here was a work release program, that is to say it was work-related in education, is it your position that because this defendant, Donohue, had not served the requisite number of days, notwithstanding 86F, he could not be released on a work release program?
No, he could be released on a work release program, but we're saying this goes way beyond that. I mean, allowing somebody to work during the day and go to their home at night, that's what most of us are doing today.
So you're saying work release means out during the day to work and back into the institution at night?
That's right. To allow them to live in the place where people under the law traditionally have the greatest amount of liberty, when they've been sentenced to the place where people traditionally have the least amount of liberty, is not what the statute could have intended, and it's not what certainly not what the sentence
Is there
intended.
anywhere in the statute when it talks about the participation of inmates in the programs outside the facilities where it says that the inmates who participate in these programs may live at home?
I'm sorry, can Your Honor?
Is there anywhere in the statute where it says that any place in the statute that says that inmates who participate in these programs outside the facilities, that they may live at home?
No. In fact, the statutes say that they have to be fed, housed, and supervised in a separate place or part of the
Separate
the
space
facility.
or part of.
Right,
Well,
and that's
how did we jump from the program that I always thought this envisioned, which was people who were close to parole could go out and work during the day and come back to the facility, the institution at night. How did we get from there to the program where they could go out in the day and then go home at night?
Well,
Well, first of all, technology helped.
Well, but even if they
I
could go, even if they
understand,
could go
but I
out
mean,
in the
there's a
day,
real-
they need a
that's a
place so
realistic-
they don't at lunchtime go off to New York.
right. Well, presumably it arose not so much because of what the statute provided, but because of things like crowding and budgetary needs. And that's important here because the sheriff, quite understandably, takes into account those types of things, overcrowding and budgetary constraints and public will. But those are the types of things that judges are supposed to. That's why we have judges making decisions on sentencing, because they're impartial and they're not restricted by
Okay.
those things.
Well, my question, I guess, is how does this statute, these statutes, how do they authorize people to live at home at night?
They don't.
Yeah, well, I don't see how that's been answered by the,
No, whatever decision we make in this case, I take it should not necessarily, well, let me ask you, does the decision we make in this case depend upon the existence of an overcrowding order in Worcester? Because if that's true, the decision will only apply to counties where there's overcrowding. And I take it there's another 10 counties out there, or maybe 8 or 9, that are not subject to overcrowding issues. And the question is, does this statutory interpretation apply to those counties as well?
It would, but then we would need to look at, on a case-by-case basis, at exactly how those programs are working and whether they're consistent with the statute or violate it, and very importantly, whether in each case the placement in the program is in violation of the sentence. Because that's something that the letter from the Secretary of Public Safety leaves open. We know people are in these programs elsewhere in the Commonwealth. We don't know whether or not it violates the sentence. So a lot of their doomsday scenarios are speculative.
Secretary also doesn't comment on whether the Department of Corrections currently has such programs.
That's correct.
Thank you, Mr. Labott.
Thank you, Your Honor.